Ondoka, good to have you on Arise News. Thank you so much for joining us on Newsday.
Thank you very much for giving me the opportunity to be here again.
Well, you're welcome. Now, there's been some controversy over the interpretation of Section 134 of the 1999 Constitution. Some legal scholars believe not having at least 2/3 of all states in the Federation and the Federal Capital Territory, Abuja, nullifies the presidential election results declared by INEC and will form the thrust, of what happens at the Election Petition Tribunal. What's your thoughts on that?
Well, thank you very much. I have spoken so much about this and I wouldn't want to be personal. But I wish to draw the attention to the reading of a document, the requirement of a law. The Constitution is a document, and for you to get the true intention of a particular provision of the Constitution, for instance, Section 134, subsection 2, you have to read the entire Constitution in reference to other provisions of the Constitution. That is where you will get the true meaning. Today, I don't want to specifically talk about Section 134, subsection 2, but to give you other background provisions that if you want to construe that provision, you must also have to look at them to give you what you are looking for. First, let's look at the Constitution itself, Section 1 and 2. And Section 1 said Nigeria should be a federation consisting of the state and the federal capital. That is the beginning. Should be a federation consisting of states and federal capital. That appeared there. If you go back to the sections, Section 3 of the Constitution, it went ahead to list the 36 states of the Federation by name. From there up to Section 6 of the Constitution, you will discover that what is local government is specified, what is area council is specified, the area of the states are defined in the schedule, the area of the Federal Capital Territory is defined in the schedule. So you will know that there's no mix-up of what is federal capital or what is state, because they are specifically mentioned, and the rules of interpretation is that what is specifically mentioned in the Constitution or in the document, what is not mentioned is excluded. So if you look at it, the states are well defined, their territorial area well defined, even their capitals are well defined. If you come to the issue of the federal local governments contained in all the states well defined, and then the Constitution does not pretend in federal capital to say they have a local government, say they have 6 area council, specifically defined in the second schedule of what is the federal capital. Then if you go back to Section 133, B of the Constitution, which deals with presidential election, which comes before Section 134, you will see that a person who is a single candidate at the election is still stipulated to win 25% in 2/3 of all the states and federal capital. And it goes to say that if somebody is not elected in accordance with the Constitution, fresh nomination should be. That one has gone further, not talk of fresh election. It's a fresh nomination should be taken. That is how serious it is. If you marry that provisions, you'll be able to arrive at the true intention of Section 134, subsection 2. You must look at Section 133. Because the person is just a single candidate, yet the stipulations say you must get 2/3 of yes or no in the 2/3 of the 36 states of the Federation and federal capital. And if he is not elected, there's no winner in accordance with the provisions of Section 133, fresh nomination, not election, fresh nomination should be conducted. That is in the case of a single candidate. So when you come to 134, which deals with multiple candidates, 2 or more candidates, the procedure is almost the same. And came again. Where it's being argued, maybe rightly or wrongly, that Section 299 makes the federal capital a state. I'm afraid where something is specifically mentioned, where defined, I don't think importation of that kind of interpretation may be appropriate. But that is still left to be resolved by the aspect. But assuming you don't look at that, 299, and equate it, you will see the special nature of the federal character, because there is also specified that the president should act as if he's a governor. And therefore, one may be tempted as the federal capital is created, given a special nature. And if you look at it literally, if he's deemed to be a governor, Section 176 of Section 2 of the requirements of winning 2/3 must have applied. But here the Constitution stipulated it should only be 25%. I thought that is the more proper consideration, because if you are saying it's a state, then the issue of requirement of winning to the federal capital by 2/3 as specified in the governorship election will arise. But I don't think that's what is the import of the Constitution. But so much has been said, has been repeated about this. I just drew the attention to the other sections of the Constitution that can give more light, because the interpretation rules say make reference to other relevant provisions of the Constitution for clarity. And again says you should read the whole documents as a whole. Section 299 appear to be more consonant with the administrative procedure, which gives the state, the federal capital, the power to the president as if he's a governor to administer the federal capital, and the National Assembly as if it's a House of Assembly to make laws for the federal capital. That is my understanding of it. But it has generated so much and it's in court. I'm afraid we'll see what the judges will say.
Definitely, we have to wait and